Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a fabulous webinar conducted by a brilliant construction law attorney, Leslie Bowe, a contractor, subcontractor, and supplier step-by-step guide to getting paid. So without further ado, I would like to introduce the incredible Leslie Bowe.
Thank you so much. I'm happy to be here today to talk on this topic. As a construction lawyer, this makes up quite a bit of what I do day in and day out, is trying to help my clients get paid. So I'm pleased to be here and share some key steps that you all can take to help you secure your right to get paid. Just a little bit of webinar info. So if you have questions, there's a chat box on the right. Please enter those in. We'll get to those at the end. And we'll jump right in here. So a brief overview of what I'm hoping we have time to hit on today. First of all, a key step before you even walk on a job site or sell any materials for a project, a key to really making sure you're protecting all of your rights is to negotiate and understand your contract. So we'll talk about some key contract provisions a little bit today. Next up, we see a really useful tool in helping you get paid and move a project along and avoid protracted litigation is bargaining for and using effective dispute resolution throughout the project or afterwards, depending on when a dispute may arise. Then we will also talk about, this is another thing to do on the front end before you all start working, would be investigating and obtaining adequate assurance of payment. So we'll chat about that. And then once you're actually working out there or furnishing materials or equipment to a project, we always want everyone to really document the project, your work, what you're doing, what others are doing. So we'll chat about that as well. And then when you do get hints of problems, slow pay, or no pay, unfortunately that can happen. We think it's really important to know when you can suspend your work, or at least when you have the right to do it, even if you aren't going to, so that you can have some frank conversations with the other contractors on the project, the higher ups, and make some decisions about how to proceed. And then finally, to preserve your claims. So we want all of our clients to be mindful of what they need to be doing to preserve their mechanics lien and bond rights. And we'll have a whole separate webinar about how to file and prosecute your lien and bond rights. But I do want to highlight today some key issues that you'll need to know on, early on as far as notices and deadlines. And then we'll also touch on just preserving your claims against your downstream subcontractors and suppliers in case you get hit with any back charges that you need to pass that on down the road. So jumping right in. First up, key contract terms impacting payment. So, in theory, every bit of your contract matters. But I've just listed a few contract terms here that we see litigated quite a bit in payment disputes. So scope of work is really important. We want all of our clients to have their scope of work very clearly defined in their contracts. And this not only includes the work you intend to do, but any exclusions that you need to make as to the work you have agreed to do for the price. So if you've got a very good scope of work set forth in your proposal or estimate or your bid, we would love to see that incorporated into the contract or at least replicated there. So you can imagine there are disputes that come up when we don't have a really clear scope of work and we end up arguing about whether or not some work is a part of the contract already or you're entitled to extra compensation. Which leads us right into the next key clause, which would be change order procedures. It's really important that not only your office staff, but your project staff understands all of the procedures that are required to get change orders executed and to get paid for them. So with regard to change orders, there can be several aspects, but you really want to make sure you understand all the notice requirements how much time you need to, what kind of time frames you have to submit your request for extra payment with regard to extra work. Not just payment, but also maybe extra time. If you've got time, if time is of the essence in your contract and you're going to need extra time to complete your work, you also need to be aware of how you go about those procedures. This leads also into notice dates and delivery of notice. So you might have to give notice of all kinds of things, not just change orders. You might have to give notice if other contractors are impacting your work, if you're being delayed by owner decisions. So run through the entire contract, make sure everybody's aware of what notices are required and also how you have to deliver those notices. So sometimes we see things come up where, well, we knew we had to give notice of this, but their staff changed throughout the course of the project. So we were told to start sending it to this person. We recommend, even if you're sending it to a new person, you also still follow whatever the contract says with regard to delivery of notice, because you don't want that ending up being a defense to your claim for extra payment. Next up, really important with regard to your payment rights are whether or not your contract includes a pay if paid clause or a pay when paid clause. So if you haven't seen these yet in your contracts, they're probably there. We see a lot of owners and our general contractors trying to shift the risk of non-payment down to subcontractors and suppliers. So if your general contractor or subcontractor above you has incorporated a pay if paid clause, those are enforceable. They typically use language, something about payment by the owner is a condition precedent to payment. If your payment clause doesn't include that very specific language, then the courts will interpret that more like a pay when paid clause. Pay when paid clauses instead will set up just a reasonable time for payment. So it doesn't mean you're never going to get paid. You haven't taken on that risk, but you will have they will have a reasonable amount of time to pay. And we've seen in some Missouri cases that can be as much as 3 months. So pay real close attention to those. We don't have a lot of luck negotiating those out. So I always tell everybody, be aware that if it's there and you guys have to make a business decision as to whether or not you're willing to take on that type of risk on your project. And then next up is the dispute resolution clauses. So moving to the next slide, we see two types of dispute resolution avenues or methods. So first up would be the non-binding dispute resolution clauses. These are things where the parties are going to attempt to work something out, but if they can't reach an agreement, it's not a binding process. Binding dispute resolution would be either arbitration or litigation. So we see benefits to utilizing the non-binding dispute resolution clauses in your contracts on large, ongoing, long-term projects. It can be really beneficial to have methods in place for the parties to try to work their disputes as they come up. These typically will be one or all of these ones I've listed here. So direct negotiations between the decision makers, appointment of an initial decision maker like an architect to make a decision on, whether it's a change order or a delay claim, and then mediation. All of these will help the parties hopefully quickly reach some kind of an agreement as to the disputes. Obviously, if you can't reach an agreement amongst the parties, then you do still have your other dispute resolution options. And with regard to arbitration versus litigation, there's ins and outs to both of these. So when we first started using arbitration, it was a lot cheaper and faster than litigation. That's not always the case now. Arbitrators charge quite a bit. Obviously, in litigation, you don't have to pay a judge to hear your case. But we do find benefits to still utilizing arbitration, even though it might be a little more expensive in cases where you really want to have an industry expert deciding your case. So somebody who truly understands the ins and outs of the construction world. And we see that, obviously it would be really beneficial in design defect type cases, but even in payment claims, especially if you're dealing with a delay claim, it can be really beneficial to have somebody who really understands the industry. Tips for contractors on this. We like to see those non-binding resolution clauses in your contracts. We often recommend that you insist on having mediation as a condition precedent to using arbitration or litigation. That way the parties do at least have to attempt to try to resolve the matter, as opposed to just coming in and filing for arbitration or filing a lawsuit. And we already talked about the reasons why arbitration might be more beneficial. And then always we like to see everyone incorporate provisions that allow for an award of attorney's fees for the prevailing party. That way you're not having to make a big economic decision as to whether or not to go forward. Still on the front end before you start work would be investigating and obtaining assurance of payment. So definitely we recommend this be completed before you start work, but I will note you may need to revisit the issue if extra work is requested or the cost of work increases, because you want to make sure the owner is aware of it and on board with the extra costs. So within your contracts, there can be provisions that require the owner to provide financial information to the contractor or contractors with regard to their ability to finance this project. I've just noted here that two commonly used industry contract forms, the AIA and consensus docs, approach this a little differently. AIA only requires the owner provide this information before they execute the contract, and then after work starts, there's only going to be certain circumstances where they have to do so, like for example a missed payment or something. Consensus docs actually provides for the owner providing this kind of information throughout. We do see pushback on that because people are used to seeing the AIA clauses, and so they may want actual reasons for having to give project financial information. But these are things that can be negotiated, and obviously depending on the complexity of the project, may be something you really want to key in on. Tips for contractors. So I like to see these types of clauses. This is a sample clause of where a subcontractor has conditioned their bid on approval of the owner's credit, and also requires some additional information also. So not only is their bid subject to proof that the owner can pay, but they're also going to be provided with a legal description, the project owner's name and contact info. These are things that will help if they do need to file a lien or make a bond claim. And then again, just conditioning this and stating expressly in your contract that you're not obligated to proceed without adequate assurances of payment. Now this kind of covers everything. Again, negotiating your contracts can be an art form. If you get pushback, there's certain key elements here that you may decide you can't live without, or you may be willing to take some of these out, sort of depending on the project and your familiarity with the contractor or the owner and that kind of thing. Investigating and obtaining assurance of payment is a little different for suppliers. My supplier clients oftentimes don't have a lot of information about the project. We do recommend they always try to track where the material is going. That way we are able to file liens if it becomes necessary. But on the front end for suppliers, we recommend using a pretty robust credit application, with references and good terms and conditions. So this is your contract. So terms and conditions that go through all the things we just talked about in terms of you're going to be able to recover your attorney's fees should you have to enforce the agreement. Depending on the industry you're in, we may need to include some special warranties. So you want these contract terms included in your terms and conditions. And then we always recommend a personal guarantee. So if we can get the owner to sign on to be personally responsible for the entity's debts, that's just an extra tool that you can utilize in the event that you need to sue or threaten suit in order to get paid. And then also, I always say, don't just have them fill out the credit application, but actually check the references, right? It's good to have their banks when it comes time to try to collect, but it would be best if, as a part of your due diligence, you're checking out those references on the front end. Then once you actually start your project, we highly recommend documenting very well. I've seen too many claims get holes punched in them by the other side, or even not even having the appropriate documentation to make a claim. So we highly recommend documentation be a key part of what you train your project workforce on. So documentation is always best if it's standardized company-wide with consistent internal practices and forms. This not only helps make your employees make sure they're documenting correctly, but if you have a standard practice that this is always documented in this way and this way, then we have an explanation when we don't have something. So if we can say, anytime this change is requested, we always fill out this form, then you know that if you don't have that, you can actually testify with confidence that if we don't have that form, it wasn't requested. Good documentation will help establish the cause of events, reservations of rights. It can help, obviously, the notice provisions we talked about earlier, and it will help identify actual costs and delays. So if you're on a project where things are, your work is being impacted, you're having to demobilize and remobilize and move to different parts of the project, or other subcontractors are impacting your work, these are the documents we'll need 2 years later in the middle of litigation to provide to an expert to go back and actually put numbers on what type of claim you have for those, either the delay claim or the inefficiencies and that kind of thing. And then finally, for litigation purposes and reliability purposes, documentation has to be contemporaneous. So you don't want your project manager or superintendent waiting till the end of the month to go back through their calendar and their texts and their emails to try to put together dailies. You really want those happening contemporaneously, and it's actually an element of what we would need them to be in order to be reliable evidence in a trial. And then just a little bit more about documentation. Daily reports are really the backbone of your project documentation. So we always recommend that you report things that are happening, whether it's delays or inefficiencies, and keep repeating it on each daily for as long as it lasts. Because I will tell you, the general contractor or whoever it is that's criticizing you for keep bringing up these issues up in your reports are the same ones that are going to point to the fact that it's not there as a defense to try to pay you. Always call out other subs that are interfering with your work. Never complain about your own company, but do document material deliveries, manpower, equipment, weather. These are the things that help us go back and reconstruct what happened on a project down the road. Also, because in today's day and age, we have so many ways that we can communicate, and email and texting have just changed the way that we communicate. So I always like to reinforce with my clients that you still need to keep things professional, a little bit formal. You don't want to be joking around, using foul language, off-color humor in your communications. You want to keep the content of your communication, if possible, limited to one project. That will really help when you're trying to figure out if you're talking about a delayed delivery and you're talking about 3 different projects, you're working for one general. It's really helpful if we actually are able to pin down which project we're talking about in this email because you've limited it to one topic. And then always watch out for attorney-client privilege issues. Unfortunately, with email, things get forwarded. So if something's been circulating internally and maybe it went to the lawyer for comment or input, and then it comes back, and we don't want someone just forwarding that outside. So be careful what you're forwarding and be aware of attorney-client privilege issues because you don't want to waive that privilege. So in the event of non-payment, either when you're getting hints that payment is going to be a problem, either things are starting to be slow pay or you're actually just not getting paid, it's really important to know what your rights are to suspend work for non-payment. So if your contract doesn't have a clause that expressly states, hey, if you don't get paid within 7 days, you have the right to suspend work or something like that, then we see these pay when paid clauses and pay if paid clauses come into play in this type of an analysis by the court. So if you have a pay if paid clause in your contract and no provision that allows you to suspend work for any certain circumstances, then you are probably going to be, your lawyer's probably going to not recommend you suspend work because you would be taking a real risk in doing so. Pay if paid clauses are looked at as risk shifting clauses to where the subcontractor is taking on the risk of overpayment. Pay when paid clauses, because we talked about, those just are interpreted by the courts to mean payment within a reasonable amount of time. You may have a better argument to suspend work if you're dealing with a pay when paid clause in your contract. We always recommend you talk to a lawyer before you actually suspend work or pull off a project, because you are taking on some risk when you do that. In the event of non-payment, so we have some great tools in mechanics liens and bonds to protect your right to get paid. And we, like I said, we'll have a whole nother seminar about the ins and outs of how to do that. But I did want to put you on notice of some of the things that you have to be aware of early on in order to preserve those claims. So in Missouri, original contractors need to give a special statutory notice, and it has to be given early on in the project. So it has to be given before you get paid anything. And it can either be in your contract, so you give it when the contract is executed, or it can be when the materials are first delivered, or when work is commenced, or with the first invoice. But in any case, it has to be before you get paid anything. And if you don't have that, if you haven't provided that notice, then you will not have lien rights. So be aware, we like to put it in all of our, anybody who's actually working directly for an owner, we want it in your contracts, we want it on the back of your delivery tickets, we want it back on your, included in your terms and conditions. Missouri lien deadlines are a little bit longer than many other states. We have 6 months to file a lien, but be aware that subcontractors have to provide a special notice to owners 10 days prior to filing the lien. So you don't want to wait to the last week and try to be rushing around. Be aware that equipment suppliers, and this means people who are just furnishing equipment, not someone who is including equipment rental as a part of their performance of work. This would just apply to just an equipment rental company, and all they're doing is furnishing equipment. If they have a claim of more than $5,000, in order to file a lien for it, they must have given notice to the owner within 5 days on the job. So sometimes I'll see clients from other states, and they're not getting paid, and they didn't know about this, so they haven't provided the notice. So we provide it as soon as we can, but they can only go back, they can only file a lien for the amounts due that are covered by the notice. So if they didn't give the notice for the first 2 months, then we can include that in a breach of contract claim, but it's not going to be a part of their lien claim. And then just be aware that on residential property, there are special rules. So on new residential construction, in order for your lien to apply to a new purchaser of that property, you would have to have recorded and posted something called a notice of rights 5 days before the sale. You would hopefully know about your need to do that, because an owner is supposed to do their version 45 days before the sale. They do a notice of intended sale. But if the owner fails to do that, that is not a defense to your failure to post your notice of rights. And then residential remodels, so existing residential, not new residential, we are also required to have signed another statutory notice called the consent of owner. The general contractor is obligated to provide that, and it's supposed to be a part of a subcontractor's lien. We do have, part of that statute does say that failure to provide that is only a defense to a subcontractor's lien to the extent of payment. So if your general didn't provide it, you might be still okay. You can still have a good faith basis to file a lien. It's not going to be slander of title, but the owner would have a defense up to the amount of payment. All right, I'm going slow today, sorry. So bond deadlines, just be aware that if you don't have if you don't have lien rights, you may have bond rights. So we see bonds on all public projects, but we also see bonds on private projects too these days. So in federal projects, you would have to give notice of your claim within 90 days of your last day worked. State and private projects don't have statutory notice deadlines, but they can be in the bond. So you'll have to review the bond, and back to the whole, what should you do before you start working? If it's a public project, we like to see people get copies of the bonds early on and not wait till you're not getting paid. And then preserving your claims against downstream subcontractors and suppliers. So we want you to be using contracts with pass-through flow down clauses and pass-through clauses, such that if you get assessed a back charge by the general, if it is actually one of your subcontractors or suppliers' fault that this back charge got assessed against you, you can then go after them to recover those costs. And then tips for contractors here. We just talked about this. Get copies of the bonds ahead of time if you can. Review them. Know what the notice requirements are going into it, so you aren't struggling after you're not getting paid. And then a topic for another webinar we have on the calendar is lien waivers and broad lien waivers and bond waivers. So don't waive your rights by signing a really broad waiver. We want you to review those waivers that you sign and make sure that they're not giving away your rights inappropriately. And then always follow all the requirements in the bond when you're making your bond claim. So to wrap it up, key is always, of course, doing business with reputable and financially sound subs and suppliers, but also entering into written contracts or purchase orders and using credit applications of your supplier so that you have contractual obligations that you can hold them to. And we already talked about flow down clauses. So that was a quick overview of steps you can take, but do we have any questions?
We're going to open up the question box now, and so far we don't have any questions, but interestingly enough, on this webinar we have general contractors as well as some suppliers. And a question that was recently asked, while people are thinking if they do have any questions, we went over this very recently, that again, if you're a supplier working on residential property, that required notice that you were speaking about, if the general contractor doesn't actually provide that to the owner of the project, they could still have lien rights. However, and please correct me if I'm wrong, the supplier can only receive what has not, so example, it's a $50,000 project that the supplier hasn't been paid for. I'd love for you to finish my sentence for me.
Yes, so they will be able to file a lien for the amounts that the owner has not paid, attributable to their work. So I apologize, I kind of cut out there. But if it's a $50,000, if the supplier's owed $50,000, and if owner has paid the general contractor, I don't know, 35 of that, then they would be able to defend the lien, and the lien amount would get reduced by that 35.
Perfect, perfect.
Unless the notice was properly given, and then it's not a defense, and the owner might unfortunately have to end up paying twice.
Very unfortunate, which I'm sure you see all the time.
Yes, explaining to owners the ins and outs of lien claims is not always a pleasant conversation. But we do talk with them about, next time things to do. Make sure you acquire lien waivers in exchange for each of the payments that you're making. So there are ways they can protect themselves, and it's a hard lesson to learn sometimes. But our society puts a priority and values improvements to real property, and that's why we have these statutes to protect the suppliers and subcontractors and general contractors who may end up not getting paid otherwise.
Right. Well, if anyone does have any further questions, and you are, after this webinar, go, oh my goodness, there was this question, I should have asked it, please feel free to reach out to Leslie or send me an email at any time. I think we have a few more slides. If you would like to point your mobile phone at that QR code and give us a review, we would love to hear from you. We'll hold that up for maybe 10 seconds. Again, it'd be great to hear from you if you enjoyed this presentation. And I think we can move, yeah, go ahead, Leslie.
Okay, so a couple seminars that we have on the calendar coming up is what happens after I record my lien? How do I get paid? So that'll go into all the details of prosecuting your lien claims. And then, like I just mentioned not very long ago, we want to make sure that any lien waivers or releases that you're signing are not too broad, that they're appropriately limited to either in time or in amounts to what you're actually getting paid for. And sometimes that means writing in, a reservation of rights with regard to a pending change order claim or delay claim. So definitely don't sign waivers or releases without reading them very carefully.
Great.
All right.
And Leslie,
well, like
good.
Gabriella said, happy to answer questions if someone wants to call or email. I'm happy to do that.
And Leslie's pretty amazing because she provided us with this incredible webinar, not feeling well at all. So Leslie, you are truly incredible.
Thanks.
So thank you so much again, Leslie, and I wish everyone a sunny day.
Thank you.